Welcome back everyone to our second and last panel, which is titled Rule of Law, Democratic Resilience and Trust in EU Institutions. I'm very happy to have with me an excellent panel with Anne Fitzpatrick, Advisory Counsel at the Office of the Attorney General of Ireland, Anna Koukkides-Procopiou, former Minister of Justice and Public Order of Cyprus and President of the Politeia think tank, Shana Cohen, Executive Director of Think Tank for Action on Social Change, Natasha Mavronikola, Professor of Human Rights Law at the University of Birmingham, whom we have online. Thank you so much for joining us, Natasha. And Professor Patrick Geoghegan, Director of the Trinity Long Room Hub and Professor in History at Trinity College Dublin. I'm Nicholas Kyriakidis, Executive President of Cyprus Forum. I also have a legal background and I'm very happy to moderate this discussion. I would like to start by saying that Ireland and Cyprus, both systems are deeply shaped by the common law tradition, though Cyprus should be described as a mixed system. I should also note Ireland's practical role in Cyprus's justice reform. The functional review of the court system of Cyprus was carried out by the Institute of Public Administration of Ireland between May 2017 and March 2018. And I think this is a strong Cyprus-Ireland bridge and should be discussed in the panel. I think this discussion brings together three ideas that are often treated separately, which are the rule of law, democratic resilience, and trust in European institutions. In practice, they are inseparable. A democracy is not resilient merely because it holds elections. A justice system is not trusted merely because it is independent. And European institutions do not command legitimacy simply because they speak the language of rights and values. As I said, there is also a particular Cyprus-Ireland connection in this discussion. Since Brexit, Ireland and Cyprus occupy an interesting position within the EU legal order. Both are legal systems deeply shaped by the common law tradition, and I think that shared legal vocabulary matters, at least for the ones in the legal world. As I said, there is also a more direct link since Ireland was involved in the recent justice reform of Cyprus. Finally, concluding my introduction, we also meet at a sensitive moment of Europe. Today, actually, the Council of Europe is meeting in Chisinau, and a declaration on migration and the European Convention on Human Rights is expected to emerge, and this will be probably discussed by Natasha. The central question of this panel is how can European democracies reform, adapt and respond to public pressure without weakening the legal guarantees that make democracy meaningful. The format of the panel is that I will start with one round of questions and I'll give the panelists around 3-4 minutes each. Then a follow-up questions, and then I'll take some questions from the audience. This will last about 70 minutes, and we'll finish by 1 o'clock as scheduled. I'll start with Anne. Ireland and Cyprus are two small EU member states whose legal systems are strongly influenced by common law, the common law tradition. From an Irish government lawyer perspective, what does that tradition contribute to rule of law culture inside the EU, in your opinion?
Yeah, thank you very much first for the opportunity to speak today. We're delighted. Before I address your question, I suppose just to state that I suppose as the Office of the Attorney General, we are providing legal advice to government. So I'll frame my answers in that context. So obviously other departments can speak to the policy and to the relevant rule of law policy. But just going back to your question as regards government lawyers, I think it is absolutely inherent in our DNA and it is central to absolutely everything we do on a daily basis. The role of government lawyers in Ireland is not that well known, in fact. The Office of the Attorney General, we have over 300 lawyers in our office, comprising solicitors working in the CSSO, which is the Chief State Solicitor's Office, ourselves in the Attorney General's office, and even within our office we have advisory council whose role it is essentially to advise on matters of legislation, litigation and general advisory, along with our parliamentary council colleagues who actually draft legislation. And I suppose by way of ourselves as government lawyers, first of all, it's enshrined in the Constitution, that Article 30 of our Constitution, that the Attorney General is the legal advisor to government, and all of the rule of law considerations not necessarily flow from that constitutional guarantee. We also have a statement of strategy within our office which places rule of law firmly at the centre of everything that we do. In recent years, our office has adopted state litigation principles, and that is essentially to ensure that in the conduct of litigation involving the state, that essentially Ireland is the model litigant, or the state is the model litigant rather, and that essentially the CSSO as agent for Ireland in proceedings acts appropriately, puts its best foot forward, does not try to delay or hinder matters, does not lead to a situation where you have excessive costs, tries to agree matters in advance and to dispose of matters where they can be disposed of, to apologise where necessary and own up, to settle as quickly as possible. So I think that's all inherent in this rule of law aspect. Other aspects just to draw attention to this morning that may be of interest to you. The Attorney General's Office is also the guardian of the Irish Statute Book, which is a publicly available free website which comprises all Irish legislation once enacted and signed by our President. And it's in Irish and in English, so it's in both official languages of the country. I actually sit as well on an access to legislation interdepartmental group at government level, which comprises representatives from the Department of the Taoiseach, the Houses of the Oireachtas and the Law Reform Commission, and we are very interested in how we can optimise and basically make more accessible this legislation, and to make it more reader friendly, of course, is an underlying theme therein. And within that group we have great and close collaboration with our partners in the Oireachtas, the Law Reform Commission, and in fact there's a very important project known as Rocktra that's going on in our office at the moment, which is to create an enabling tool, a software tool, to basically help our parliamentary council colleagues to better produce legislation in a way that is more user friendly, in order to facilitate and enhance this access to legislation in the long term. So in terms of our role as government lawyers, I should say as well that our role breaks down into domestic advisory work. So we are public lawyers. We are advising day in, day out on constitutional matters, administrative law matters in an Irish context, EU law matters, and obviously the ECHR law, which Natasha will speak to in greater detail, is a huge part of our role. And how does that manifest itself? It means that in everything that we do, be it litigation or legislation or advisory, we are guided by the provisions of the Constitution, most notably the right to a trial in due course of law, access to justice, the fundamental rights provisions in our Constitution. And in addition to that, on the EU law sphere and angle, we are constantly alert to and looking for opportunities to assist our clients in getting involved and actively participating in EU proceedings, be it preliminary reference proceedings where Ireland might want to intervene, or infringement actions. And just to give an example of two recent iterations of that, the Attorney General himself appeared in both of the recent infringement actions against Hungary, the recent really important values case, the violation of Article 2, and the Sovereignty Protection Office case, where the Advocate General Koukkides has given her opinion and we await judgment. So there's a real push to basically not only speak the policy language, but in our context to make the necessary interventions in legal proceedings where Ireland can assert those values at their height. And I suppose this is consistent with any public utterances we have to date about plans for Ireland's EU presidency at the end of June, starting in July. And I know that those presidency priorities will become clear within the month of June, but Minister McEntee has made clear in a speech in this very place back in January the importance of EU values as being at the cornerstone of Ireland's EU presidency, and obviously intertwined with that is the rule of law. I should also mention that in this context, our office provides assistance on, for example, international negotiations and EU negotiations where rule of law issues come to the fore in all policy areas and spheres. I'll point to one that's in my own sphere of work at the moment, which is the multi-annual financial framework. So obviously since the budgetary conditionality has become a huge factor since the regulation has come into force, and the tying of rule of law commitments to financial penalties or withdrawing of monies, this will probably come into quite sharp focus as these negotiations for the next iteration of the multi-annual financial framework ramp up ahead of 2028. And this horizontality and conditionality of rule of law is obviously an important position for many member states, and Ireland will be one of those. So I suppose, just by way of introduction, I think as government lawyers, we breathe, eat and sleep this rule of law consideration. Obviously, we are led by the policies that are brought to us by our government departments, and it is our job, in our unique role, and in my unique role as an advisory counsel in my office, to be at the intersection of law and policy, to interrogate that policy, and to be conducting the necessary checks and balances and ensuring and posing those questions as to whether relevant rule of law considerations have been met, be it a constitutional guarantee that should be adhered to, or procedural administrative law guarantees like the right to fair procedures, the right to an appeal or a judicial review mechanism, or the right to an effective remedy effectively. So I suppose, just by introduction, it permeates absolutely everything that we would do. Obviously, we will give advice, and that advice can be taken, or it might be nuanced, or it might be partially adopted or not. That's a matter for our clients, but we serve our clients with that at the forefront of our mind. So hopefully that's helpful.
Thanks very much, Anne. Let's go to the other Anne, which is Koukkides-Procopiou. You served as Minister of Justice and Public Order during a period when Cyprus was still dealing, and it is still dealing, with major questions of justice, public confidence and institutional performance. From your experience, what is the hardest part of reforming a justice system? The law, the administration, political culture, or public expectations?
Thank you, Nicholas. Let me just first start by saying, by extending my thanks to everybody who's here today. Politeia, the think tank that I'm president of, is one of the supporters of this event, and I must commend Cyprus Forum for doing an excellent job in bringing this very knowledgeable panel together now, and the previous one extremely interesting. We are very proud to be working with you. Also, I must say that when I served as Minister of Justice, we had an excellent collaboration with the Irish government, exactly because there were points of interest due to our legal systems being based on common law, and Ireland had led the way in approaching Cyprus and Malta and trying to figure out some kind of understanding. With the absence of Britain from the EU, we had to sort of form a very own caucus, let's say, within the EU, and make sure that points of concern were heard when decisions were taken in a room. Now, coming back to your question, I believe the most important question to ask when you're trying to reform the justice system, any justice system, is always the why. Why do we want to reform the justice system? And what is the purpose of the justice system itself? How is this related? How is the rule of law related with democracy and resilience? In my mind, it is extremely related. It is the pillar, it is the foundation of democracy. And if the rule of law is undermined, then the resilience of a society, the resilience of a democracy are threatened. And let me explain this. I always saw the rule of law as one of the fundamentals of a democratic system. And we'll go back to the Greek idea of democracy. It is based on isonomia, isegoria, isokratia, equality before the law, the equality of rights, and freedom of speech. So you cannot have any kind of belief in the democratic system that you live in unless you actually feel, you believe, you experience the equality before the law. Now, the big problem we have in Cyprus is, of course, delays in the judicial system. And of course, we all know what is said. Justice delayed is justice denied. So, in terms of public opinion, I had, as minister, and ministers after after my term, always also had to deal with this. Public opinion being very, let's say, being in great disbelief of justice ever being able to be to come to any productive results within reasonable amounts of time. And this creates an incredibility into the accountability and the effectiveness of institutions. And we've seen in many recent polls in Cyprus that the notion of justice has been watered down, I would say, and there's great disbelief in the institutions. Now, the tone from the top doesn't help. And I mean, of course, the dismantling of institutions, or at least the belief in institutions, that is coming from the United States of America and its current leader, who disputes what the courts say, will not implement or comply with court decisions, who will badmouth the rule of law and the international norms and values of international law. So that doesn't help. I think the whole culture is not conducive to a belief in the power of rights and law. Now, this is very dangerous. Why is it very dangerous? Because if we go back into the basic notion of national interest, what is national interest? It is the preservation of the state. What is one of the fundamentals of preserving a state? Is for the state to have endogenous resilience. It's a very important factor when we factor in security equations. How much of endogenous resilience, how much of social cohesion does this country have? So if you undermine the belief in a just society, if people no longer believe in the institutions of the democracy they live in, they don't think that there is isokratia, isonomia, and isigoria of any kind. They are more prone to believing any kind of fake news, the sinister, sharp power, let's say, incursions of not so benevolent actors who want to play within your domain. They get multiplied, and no names, but it happens, and we all know that. We call them hybrid threats, but they're part of everyday life now. It's another kind of war, and it exists. So if your society is not cohesive, if citizens do not believe in agency, if they don't think that where they live in is a just society, resilience is low, belief in democracy is low, and this creates a lot of dangers. And in the case of Cyprus, reforms are still going on. And I will very, very briefly say that we had a top-down approach, starting with the reform of the Supreme Court and creating a constitutional court at the highest level, an appeals court, a commercial court, and a maritime court. But the big bottleneck is in civil cases at the district courts, and that hasn't yet been dealt with. Digitalization of the justice system hasn't really worked. We've experimented, not fruitful yet, unfortunately, for various reasons. And the fact that there's been, let's say, a lot of corruption claims against very prominent people within the polity, within society, and the anti-corruption authority is not, which is a rather new institution, has no substantial powers in investigating anyone. Plus, the new lobbying or anti-lobbying legislation, if you like, is still a bit confused and is not really working as much as it should, because it has teething problems, and it is understandable. All these are conducive in making citizens be very, very suspicious of institutions. So if I could narrow my answer down to two words, I would say political culture, which doesn't seem to understand the importance of reforming the justice system and why it needs to be reformed. And secondly, which is basically they're mutually reinforcing concepts, public opinion being extremely suspicious of any kind of attempts of reform, because they always seem to think there is some kind of malevolent agenda behind the reform. So it's difficult, but it needs to be done. And I wish, sincerely luck to the people there handling it now, because it's not a very easy task.
Thank you a lot, Anna. Actually, I fully agree with the central point that should be in the public discussion now on an EU level is the trust in institutions and how to reinforce this trust. And this is what was discussed last week at the Rule of Law Conference in Cyprus, where Commissioner McGrath also attended, and the President of the Court, Lennartz, was also there. And exactly on the issue of trust, I want to turn to Patrick and ask from, as a historian of Ireland, and I think indeed that the common law tradition it changes the whole perspective on how we see institutions and trust in institutions. And I want to ask, how do you think we should understand trust in institutions? Is trust built mainly through legal design or through historical experience, political struggle, or public memory?
I think that's a really good point. And just first of all to say, delighted to be here and to be able to take part in the discussion as part of Cyprus's presidency. I think there has been an erosion of public trust, and I think it's caused by more than fake news and more than disinformation. And I think what you really need to see is institutions that are capable of dealing in complexity and ambiguity and embracing disagreement. And I think that's a role that I think the universities can play and have to do more to lead in this area, because universities are places where you can have slow thinking across longer periods, where you can provide this wider context, where you do deal in evidence and provide depth, and you embrace, or at least are meant to embrace, plural and multiple perspectives. And we are facing challenges now in the 21st century, but we have to remember, we've always faced challenges. If you look at that, people are understandably concerned about the turn the United States has taken with President Trump, but 20 years ago people had strong concerns about President Bush. 20 years before that, people were protesting in Ireland when President Reagan visited because of what was happening in Nicaragua and elsewhere in the world. 12 years before that, you had President Nixon and Watergate. And then a few years before that, you're dealing with the crisis in democracy with the Second World War. So we've always experienced these challenges, but I think something has changed in more recent times. And when Mary Robinson, after finishing her term as President of Ireland, became UN Commissioner for Human Rights and faced opposition from countries including the United States in that role, she also became Chancellor of Trinity, of the University of Dublin, and she gave a very powerful speech where she talked about how universities had to be educating people who were not going to be mouthpieces of orthodoxy but critics of the system. And I remember in later years I talked to her about that speech because I found it very powerful. She actually had no real recollection of giving it, and I was glad that it made, but I think the reason why she had no real recollection is because she was delivering it at a very time when she was being criticized for the role she was taking as UN Human Rights Commissioner, and what she was actually articulating was, in a way, also about her view of the world and all of that. But I do wonder if in the present day you see with a younger generation where the orthodoxy that they're falling into is the orthodoxy of just being a critic of the system, but not really being proactive and positive and seeing how you might contribute in a certain way, that it's very easy to tear things down, but how do you build things up? And I'm afraid you see that a lot with academics as well, who become public commentators on various issues, increasingly beyond their own actual research training and expertise, and do it in a way that they have some kind of assumed authority because they're on radio or television as a professor, and becoming experts on, or assumed experts on, housing or any of these issues, but not actually engaging with the issues or doing anything that is in any way advancing the debates, rather than destroying what is currently happening or being presented. And I think a number of academics are actually acting in a role that kind of goes beyond what they're meant to be doing. And I don't think it's of course you have academic freedom, but I don't think it's really what the role of educators is meant to be. And I think what we really should be doing is trying to ensure that when we see that sometimes our students believe that debates are settled, in our debating societies there are some topics that our students won't debate. Not because it's too controversial, but because they believe this is a settled question. And they are completely intolerant of any position that goes against it. We had Jack Power chairing the discussion earlier from the Irish Times. The Irish Times run a major debating competition. For about 6 years, our leading debating society in Trinity refused to take part in that competition because it once published an article that it disagreed with. And the Irish Times was not stocked in our students' newsagents because one article was published that they believed crossed what was. Now, we pander, I think, to that mindset. We don't challenge it. We don't encourage complexity or ambiguity. We pander it because we have this belief that, well, this issue, they're on the right side of history. We pander. And I don't think we're doing a service to ourselves, to the community, to the world, or indeed to our students. That in the past, where students were able to engage in debates and see different perspectives, I think we were talking about the historian's training. Well, as an historian, I find, even when I was working in government as an advisor, I always saw the other side. You know, when an opposition would attack somehow, I said, well, actually, they kind of do have a point, and you can kind of see from their perspective. In my mind, I'm always seeing what the other side is. And when I'm writing history, I'm always aware that there's another side. But increasingly, we don't have that. And I think that unless we become better as universities at encouraging that embracing of different perspectives, like what we are trying to do in the Trinity Long Room Hub, and we've had the ambassador in many times speaking brilliantly, including at an event on defence and security last month. But unless we do that and show how it is possible to do that, then I think we are failing as educators.
Thanks a lot, Patrick. Turning now to Natasha, who's joining us from Birmingham. Natasha, I wanted to ask you, is the kissing out debate a broader rule of law moment about whether governments can politically recalibrate convention rights when those rights become inconvenient, in your opinion?
Thank you. Can everybody hear me? Is there an echo?
Yeah, there is some echo. Let us fix it. Just a second.
That's unfortunate.
Can you speak now?
Yes. Is it okay now?
No, it's not. Okay, it's not very bad. We can ask the technician though to come and check.
Can everybody hear me?
Did you mute? Can you try again? Yeah, we can hear you, but there is some echo. Can you try again?
Yes. How about now? Still an echo?
Yeah. Okay, we'll
I can try to join you again and see if there's something on my end.
Are you joining from two devices by any chance?
No, but give you 1 second.
Okay.
If you have your mobile next to you, you have to switch it off. Not. I mean the professor.
No.
No, same.
Still not good. Okay. Let me get my phone then. Apologies. Feel free if you want to go to another speaker, I can join.
We'll move on to the next speaker. Is it from our end, the problem? The problem is from our end. Probably not.
It might be from my end. I will join you on my phone,
Okay,
and I will leave it to you in a moment.
Yeah.
Okay.
So, Shana, I was gonna say last but not least, but you're not the last after all. So, from the perspective of
She's ready though. Oh, she's not her phone.
can you try
Can
now?
you hear me?
Can you please talk?
Yes, can you hear me now?
Echo again. There is echo.
It might be from this side then. Maybe now it's better?
I think it's slightly better. Yeah, you can go ahead.
Yes.
Any better?
Yeah, go ahead. Go ahead.
I'm very sorry. Not only am I pressing you with a big image on the wall on the projector, but also with an echo. Is it working? Can you understand me?
You can go ahead. Can you hear me? You can go ahead and speak. I think it should be fine.
Okay. As well as mentioned, I want to broach the issue of the Chisinau Declaration, which has been issued today. But I wanted to begin by saying that when I was lucky enough to work for 3 years on the island of Ireland, I was able to appreciate firsthand not just how much rapport a Cypriot can enjoy with the people of Ireland, but also how much the people of Cyprus and the people of Ireland can be bound by the shared trauma, including intergenerational trauma of conflict. And one of the main areas of my research, the right not to be subjected to torture or to inhuman or degrading treatment or punishment, which is protected by Article 3 of the European Convention on Human Rights, was central to 2 interstate cases concerning our respective countries at the European Court of Human Rights. Namely, the case of Ireland against the United Kingdom and the case of Cyprus against Turkey. These cases are famous, among other things, for the findings in relation to Article 3 of the European Convention on Human Rights, which prescribes torture and inhuman and degrading treatment and punishment. In Ireland and the UK, the European Court of Human Rights found that a group of men that we now know as the hooded men were subjected to the euphemistically called 5 techniques of interrogation, which consisted of hooding, stress positions, noise, deprivation of sleep, and deprivation of food and drink, had been subjected to inhuman and degrading treatment in violation of the absolute right not to be subjected to inhuman and degrading treatment. In Cyprus against Turkey, the European Court of Human Rights found a continuing violation of Article 3 in that the silence of the authorities in the face of the distress of relatives of missing persons was inhuman treatment, and that the systematic discrimination to which enclaved Greek Cypriots were subjected amounted to degrading treatment. Both cases stand as important reminders of the violence and the cruelty when a group of people are dehumanized and othered, and the group's judgments embody a forceful rejection of the notion that it is ever acceptable to subject anyone to such ill treatment. So this is what it means to say that the prohibition in Article 3 of the European Convention is absolute. Sorry, is it still very bad?
No, now it has been fixed. I fixed it.
Okay, wonderful. Sorry for that echo, but hopefully you got the gist. Now, these were not just long-winded warm-up remarks to say, how pleased I am to be with you today, and how relevant some aspects of our relationship are to my research, but it was to put into context the alarm bell I wish to ring in relation to the topic of this panel and the rule of law dimension that Nicolas raised. Now, obviously, I'm taking a somewhat wider lens on Europe, so I'm focusing on the Council of Europe and its task in protecting democracy, human rights, and the rule of law under the European Convention on Human Rights. Today, member states of the Council of Europe adopted the Chisinau Declaration, which is a political document conveying the views of member states on migration and human rights. The declaration is wide-ranging, but I want to focus on its stance on Article 3 of the European Convention, While nominally reiterating Article 3's absolute character, the declaration appears to put political pressure on those applying Article 3, culminating in the European Court of Human Rights, to water down Article 3's protections so as to facilitate the expulsion of foreign nationals. The road to Chisinau was paved first by a letter from 9 countries, which did not include Ireland or Cyprus, last May. A letter which claimed that the European Court of Human Rights' interpretation of rights such as Article 3 had, quote, resulted in the protection of the wrong people. The momentum built by that letter was reinforced on the 10th of December of 2025 by a statement from then 27 states, including Ireland, but not including Cyprus, which emphasized the need to protect, quote, the rights and freedoms of our populations and address and recalibrate human rights accordingly. How is the Chisinau Declaration chipping away at Article 3, as someone has put it? The declaration suggests that Article 3 should not pose unnecessary constraints to expulsion. It enjoins caution in the application of Article 3 in expulsion and extradition decisions, effectively pushing for a presumption against the application of Article 3 in that context, and leans into balancing and relativist rhetoric more broadly across its text. More fundamentally, the declaration's overall message can be said to encompass and at least watered down in comparison to the previous statements and letter, a watered down carving out of a category of people whose human rights should carry less weight or should not pose unnecessary obstacles to state policy. And I would say that this arguably embodies the sort of othering that I highlighted at the start, at the echoey start of my intervention. And the political pressure that the declaration is piling on the European Court of Human Rights is orientated very much at pending cases before the Grand Chamber of the Court and future cases before the Court, something that many have highlighted as raising a threat to the independence of the Court and more generally to the rule of law. Now, several of the actors involved in this initiative are saying, effectively, that pushing this reform is needed to preserve the ECHR system and even make it more resilient. Yvette Cooper has said about the Chisinau Declaration, the ECHR has protected democracy, human rights, and the rule of law across Europe for 75 years. To ensure this continues, we need a common sense approach that reflects the realities of today. But what I want to ask is, what are we preserving here? One may say that it is common sense to channel popular concerns regarding irregularized migration into ensuring that European human rights remain aligned with popular concerns. But an alternative reading is that what we're looking at is such a reconfiguration of the fundamentals of human rights that what we are preserving is no longer a Europe that rests on human dignity and human rights and the rule of law, and that by normalizing and entrenching a rhetoric of us and them that creates something of a hierarchy of rights holders, as the Council of Europe's Commissioner for Human Rights has warned. By doing all of this, the declaration may give further legitimacy and momentum to ideological positions that push against human rights altogether and that are associated with some of the darkest times in European history. So I will leave my intervention there and thank you for your patience.
Thanks so much, Natasha, for the excellent remarks. Let me now turn to Shana, and apologies for the delay and the patience. Thank you. From the perspective of the civil society and social change, what does public trust in institutions actually mean, in your opinion? And is it trust that institutions are lawful, or trust that they are responsive to people's real lives?
First of all, thank you for inviting me. The think tank I represent is independent, though in the media it would probably be considered toward the left. And I've not from Ireland, and although I have Irish citizenship, I'm from the United States, so President Trump is my president. I should say,
No comment.
Shockingly, I didn't vote for him twice, but but I agree, he's undermined the rule of law, if we were to follow on from the discussions, but he is certainly not, he's just a model, and I think that's the bigger question. So in responding to I'm coming from the perspective of civil society, so that's what I'm going to focus on just very briefly. You talked about public trust. The other speakers have talked about public trust, but you've talked about it through the rule of law and maintaining it from a legal perspective. And you've talked about equal rights, and then you've talked about the rights, and particularly of minorities and of migrants, and weighing public sentiment with policy and policy needs. Europe has an aging population, and there's no way around the fact that Europe is going to need migration to Europe for labor market purposes. And you could look at the example of Spain as one example where they've taken a contrarian approach. And you can look at post-Brexit UK where migration's actually increased, not decreased, regardless of the politics of the Reform Party. So I would say that I'm going to just talk very briefly about the role of civil society in generating trust and where I think the European Union has gone wrong. If you look at Edelman Trust Barometer, which I like to look at in terms of just a general indicator of trust, there's declining trust in general, and the 2026 barometer indicated that there's a growing insularity, which isn't good for the European Union because there's more focus on national interests rather than international or transnational interests. So there's, but if you look at NGOs in general, it's not a crisis level yet, not like the media. There's grave distrust in the media, and there's grave distrust. If you look at polls in Ireland, political parties are always rock bottom in terms of trust level, along with media. But NGOs do not fare much better. What I found particularly shocking, and what I think the European Union should be focusing on if you want to talk about generating greater public trust, to go back to Patrick's point, it's not just enough to critique or to relay like what's going wrong. It's one of the reasons I've partly left academia, though I still have an academic career, is we need to figure out how to translate ideas into constructive practice and not just critique. But the poll, unfortunately, the Edelman Barometer revealed that less than 1 in 3 people in Ireland report engaging with diverse news, which I thought was fairly shocking. 8 in 10 have an insular mindset. This is just in Ireland. It leads to distrust in those with different values. Media, NGOs, and political leaders are all affected. The consensus across countries in the Edelman Barometer, which is not just wealthy countries, but also countries like, wealthy, but not just democracies, but countries like Saudi Arabia, is that distrust and ensuing tensions are almost at a crisis level. So this is what respondents said in the survey. And trust in NGOs, and I'm not surprised my academic career is in North Africa and partly the Middle East, which is... Anyway, having lived in the Arab world for quite a few years, I'm not surprised that NGOs are trusted more than their governments for obvious reasons, but the trust in NGOs was significantly higher, was noticeably higher in non-democracies than it was in democracies. And Ireland is in the bottom, let's say, third of countries in terms of trust in NGOs. So I'm representing one of those NGOs, and it doesn't feel right. So what can be done, to go back to what we should be doing? The EU has unfortunately had a couple of big scandals around NGOs that are linked to some of the groups in Parliament, and that has affected how NGOs are funded. But it's not just the funding that's the issue. It's not just provide more funding and then all the problems will go away. It's going back to what I think, based on my own decades of experience, is that the European Union has to go back to thinking about the basics about what is civil society. What is civil society supposed to do? And if civil society is supposed to generate public trust, then in order to do that, it needs to be mediating between different points of view. It needs to bring people together who are not in an echo chamber. And I can find that from our own work at TASC that often we end up struggling against the echo chamber. The focus both in the Irish government and the European Union has been on the lack of monitoring mechanisms, the need for compliance, the need to subscribe to increasing regulations around governance, and then shrinking funding. Even among pro-European, the European movement, that funding is shrinking from the European Union, whereas the organizations that are potentially associated with Eurosceptic organizations, that's increasing. So it's not just funding, but that should be addressed if you want to talk about what the purposes of civil society in generating trust. I think just very briefly, we have to ask what civil society is for, what it represents, and if it represents mediation and brokering trust, which the Edelman Barometer kept bringing up. It also bringing people together with diverse views. It's there to help people, but it's there to make governments accountable. It's there to make the European accountable. But most importantly, it should be there to create some sort of framework for social cohesion. And I think if we were to, as I'm finishing this discussion, if we were to translate what's been said, I think that that's the role of civil society, but the European Union needs to think about that in terms of not just its funding priorities, but also a narrative, even at the level of the Council. Thank you.
Thank you, Shanna. So we have about 25 minutes, and I'm thinking of doing another round for a reaction of each speaker, and I'll follow the same order from what we've heard. And I also want to put in the discussion that we're talking about trust and how to reinforce our democracies, and what we have been working on right now, and the EU has been working on, is how to improve our checks and balances, make democracies more resilient. But in the longer run, in the short and medium run, maybe this is the solution to come up with tools to reinforce our democracies. But in the long run, I want us to reflect how do you feel about the use of AI in decision making? Because and this is also part of my research, that we are cautious about AI, but I think we have to be cautious about human decision making, because human decision making has apparently failed us all these years, and maybe the solution to make our democracies stronger is to start considering what has been framed as algorithmic democracy, which in the end might come up with more uniform decisions, of course always with human oversight. And since we're talking about policy, and in the context of EU, try to include in your reaction how you see policy-wise the use of AI in decision making. I'll start with that.
Great. Broad question. And one I definitely don't feel qualified to answer, but I'll just give you a few remarks. The AI sphere is a particular challenge, I suppose, as a government lawyer, in the sense that we are actively, constantly working on, legislation, tools to address issues as they arise via programme for government, via departmental commitments. And it's just a fact of life that the legislation is made, a huge amount of work goes into optimising, future-proofing, trying to look around corners and think about every possible eventuality. And then some technological development comes along and the legislation may not be as, let's say, fit for purpose as one might have envisaged. And that is a huge challenge, I suppose. I'm actually working on the Irish transposition of the AI Act, and I see that, and even that has shifted. The sands have shifted because we now have an omnibus, and it's an evolving landscape. To a certain extent, is law the appropriate tool to meet those challenges? I can speak from the AI perspective of the European Union. The Commission clearly believes that their approach to even AI will be to have a series of, for example, delegated and implementing acts to supplement and amend and provide for better implementation at European Union level of AI type instruments. So I think that is almost a concession that we have to be malleable, flexible, and that having, an act that is immovable is not going to work in the long term. At a domestic level, how this manifests remains to be seen. AI, is seen as the silver bullet. I think we're all kind of grappling in our various sectors with how AI will work in our day-to-day lives. I know as lawyers we're inherently conservative. Obviously, the work of our office, we are subject to legal professional privilege, and we have all of those concerns to equate with the use of AI tools and AI resources. But I suppose just to talk more generally, and just to talk about trust and confidence and the fact that humans and versus AI, etc. I do think, and I don't want to speak out of turn, but I think there is an awful lot of good work going on behind the scenes that we can't, as civil servants, necessarily speak to. We have an AI governance code, but also I think more generally, there are many, I work with many colleagues across departments, offices and agencies who day in, day out are doing their best to meet these challenges. And they may not necessarily be those who are in the public domain. They're often the unsung heroes who are behind the scenes, ensuring that standards are maintained, that checks and balances are met, and that various government commitments have had the full rigour of, as I say, this interrogation, to use Professor Gagan's term, of both sides of an argument. I think that work is quietly being done by many unsung heroes across the system, but that they might necessarily be the ones who are centre stage. I can think of elements where this becomes really apparent. For example, in the area of electoral reform, we've had a lot of work in that area recently. Judicial reform, I mean, you've seen headlines in the last week, and I'm conscious not to speak about something that is, as I say, outside of my own domain, but even in the judicial context, we're really lucky in Ireland to have a very independent judiciary, and we see kind of the creep of AI into that space in media reports in recent weeks as well. This is a challenge. I think the only way we can all meet it is to be honest and to front up as to the limitations potentially of legislative tools in this space, and I think the emphasis on dialogue is going to be so important, and knowledge sharing, and approaching this conversation in an open and honest manner in all sectors of society, because I think we're all learning as we go. I am heartened, though, and I will say, about some of the recent developments, particularly, and I read Commissioner McGrath's speech that he gave in Nicosia last week, and I was very heartened around his discussion of civil society engagement and actually fronting up with funding to meet the societal challenges we face, and the use of the EU Democracy Shield. Now, I don't know if they're going to be legislative tools, but again, if they were, would that be more or less effective, is my question. Perhaps that is actually a very savvy way to proceed, that we have policy tools that can be tried and tested, and if they don't work, we can go back to the drawing board and try something else. I guess my worry would be that we enshrine something in legislation, we go through a very rigorous process, and we all engage with it in good faith, and ultimately we have to ask ourselves, are we able to keep up? So I think it's about looking at the soft law tools and not just the hard law legislative tools in the toolkit. And as I say, being open and engaged and honest in our communications with our citizens in that respect.
Excellent, thank you, Anna. Anne, going to Anna.
So do I get the same question then?
Yes, everyone.
Okay. Let me just reiterate what I said before. If there is no trust in institutions, then there is no cohesion in society. There's polarization, there's toxicity. And if there is no cohesion, there is no resilience. If there is no resilience, that means a society is in danger, because it is very susceptible to all kinds of incursions by third parties. And if there is no belief, if there is a vacuum, in the sense that people believe that institutions are not doing what they're supposed to be doing, they're not relevant, and they're not providing anything, then this creates a vacuum, because the people will start believing in something else. Now, how is this relevant to AI? One of the variables that I always like to look into when examining questions of such questions is the question of agency. When citizens feel they don't have agency, they don't have ownership of the institutions do not serve them and their interests and their rights, then they do not feel included in the body politic, with all kinds of repercussions that we're not going to talk about now. So with AI, my main concern, although it is a very useful tool, if we insist too much on someone else making decisions for us, then we are removing agency, and we are removing responsibility, and we are moving away from value-driven policy and decision-making. This is a very precarious point in time, if I may speak as a historian now, to do away with values. They're already under attack as it is. So if we do still believe in democratic institutions, if we do still believe in the EU as a multilateral way of moving forward towards the future of its member states, I believe we should insist a bit more on involving citizens, on bringing back agency. Now, the counter-argument, of course, could be that there are many technological tools which could get citizens involved in democratic processes, in conflict where I do some work. We talk about peace tech, which allows deliberation between citizens. There's been a lot of talk of deliberative assemblies and all kind of technological tools which allow that. I am in favor of that, but then there are dangers, because then there's the other side of the equation, of course, is how safe are these tools from manipulation. I may be a traditionalist in what I am trying to say, but I do believe that inclusion is a key word as far as security is concerned, as far as democracy is concerned, as far as the rule of law is concerned. And the whole argument about the rule of law boils down to two fundamental questions. Does the law work, and is the law relevant? I think that's the fundamental question we need to sort of think about and respond to before we start thinking about the tools we may use to that effect.
You said how safe are technological tools from manipulation, but how safe are humans from that manipulation? Maybe less safe.
May I just come in on that? I think you raise a very good point around the technological tools, and I think as well we have to think about the legislative framework we have already. I often think there's a tendency when we have new technologies, and AI obviously has been around for a while, but which has now gone into overdrive, is just to remember, to take a minute to remember what we do have in terms of legal frameworks, from GDPR to digital services to digital markets, to all of those really important and robust guarantees that we have, both in the Charter of Fundamental Rights, in the European Convention on Human Rights, and in Ireland within our own constitutional traditions. So it's not like AI is not coming to us and we don't have to legislate for it and try and regulate every aspect of it as we go. There are fundamental and robust protections which have been there for decades that are there to assist us with these challenges. And I just remember our former Chief Justice Denham, was saying that our constitution is a living document. And I mean, the same argument can be made for the treaties, and although they have had their relevant evolution, they've been pretty stable for the last 17 years, and in terms of the Lisbon Treaty, there is enough in there. There are ample textual bases to do a lot without having to change too much. And I think sometimes there's a rush to change, to amend. We have, we both come from countries and we're operating within the European Union which has very robust safeguards in place, and sometimes the answer is less, I would suggest, potentially, and not more.
Thank you. Now turning to Patrick, what's your view on that?
I'm fascinated by AI because it's the topic in Trinity that generates almost the most interesting and heated debates at the moment. And you have some who are absolutely enthusiastic adopters, and then on the other side, those who are strongly opposed to its use in any form for ethical, environmental and other reasons. And then you've got others in the middle who see it as a possible tool and a resource, and how to use it and how to adopt. I suppose the concern I would have is that it's one thing if you've been trained in different skills and then you can use it as a tool, but for those who are taking a shortcut and instead of actually first learning those skills are then relying on it, I think it's much more dangerous and destructive. In terms of the decision making, very struck by what's being said about, I think that there is that kind of distance, and it can be from people and citizens. When we talk about the institutions, we also talk about the citizens and how they feel engaged. And I think we were never at our most European in this country than during the whole Brexit period. We saw what had happened to our nearest neighbour, and even those of us who might have had doubts about bureaucracy or accountability or anything, we were all proud Europeans and we saw for the first time very clearly the chaos and everything else that happens when without Europe. But then in recent years that has fractured a little bit, and I think Harry mentioned Gaza. I think Gaza has damaged certainly increasing the way young people view Europe and the institutions, and migration appeared in that recent European Movement Ireland survey. But I do think that when we talk about European values, do we see them as our Irish values as well? And that sometimes we talk about, oh, we could have a guest from Ireland or we could have a guest from Europe, but it's Ireland and Europe. And I don't know. I sometimes think that we need to go beyond institutions, and it's about, when we talk about Europe, it's sport, it's culture, it's music, it's roaming, it's, you know, travel around, it's Erasmus Plus in education, and it's colleagues like around here. And I think when you put the human at the centre of it all, it's much more powerful.
Thank you for that, Patrick. Going to Natasha.
Thank you for a very hard question, and I would echo much of what has already been said. I suppose looking at it from a rule of law and a human rights perspective, certainly those of us who care about the rule of law and human rights should be very conscious of the flaws and the limitations and the risks of AI, but not hesitate to pay very close attention and even get involved in how it is evolving and how it is impacting on the sorts of things we care about. Now, from the lens of the rule of law, it's interesting what you say, Nicola, in terms of algorithmic decision-making and how perhaps one could argue that it advances some aspects of the rule of law, such as potentially, in its less flawed version, certainty, consistency, foreseeability, and maybe even a sense of equality before the law, insofar as that amounts to a sort of bare consistency. But, and I think Anna certainly highlighted this dimension of agency, I think that the egalitarian and dignitarian aspect of the rule of law definitely has this human decision-making component to it, the human-to-human sort of component to it. And in addition, the accountability aspect and the responsibility aspect of the rule of law raises serious questions about algorithmic decision-making. And since I am in the mode of ringing alarm bells, I would say that we need to be paying close attention to what happens after Chisinau in relation to some of the assessments that will happen at the state level across the Council of Europe with respect to expulsion, removal, or extradition decisions, because at least when it comes to Article 8 of the European Convention on Human Rights and the right to family life, to private and family life, we might be looking at effectively the complete negation of a right to individualized assessment in relation to the sort of risk that somebody might be facing upon expulsion, removal, or extradition. And algorithmic decision-making can be playing an increasing role in that. I'll leave my intervention there, but I have to dash out in a couple of minutes. So I wanted to also take this opportunity to say a huge thank you for including me in this event and for accommodating me so patiently, and to say what a pleasure it was to be in your company. Thank you.
Thank you so much for your very thoughtful comments, and thank you so much for being with us, Natasha. Turning to Shana for your view on that.
I would just draw on we've worked a lot with AI in the past couple of years, and we did a work for the Financial Services Union on how AI is influencing the delivery of financial services to the workforce. And what we did drew upon the negotiations between screenwriters in Hollywood and movie companies. So you can't, and I think that those are illustrative, that there has to be some sort of, not to introduce new legislation, because this was a union, these were both unions who were trying to argue with employers or negotiate with employers, what we're finding is that there has to be a well thought out relationship between analog and AI, and that the human being is first, and it's how AI can enhance their abilities, but it's also, you'd want to avoid the problems that would just like ironically the high-tech companies are going to face, because they're not hiring, then they're hiring, they're laying off, they're rehiring, but what it does is it makes young people or even older people within their workforce is very jumpy, and so you end up using AI, but you've got a social problem, or you've got an unemployment problem, and that will cause blowback. And then to go back to the lack of public trust, they'll go down a rabbit hole because AI may lead them that way, and then you've got a real political crisis on your hand. So I would just, I would strongly contest the idea of embracing AI as a technology without contextualizing it within the workforce and within kind of the need to go back to this kind of public trust will only really improve at the low levels it's at right now with transparency, but also dialogue between people who don't, analog dialogue between people who don't share the same points of view, and AI doesn't contribute to that necessarily. And I'll just end it with one last point. Younger workers in particular need support, because not just because they're finding it difficult to break into the job market, but also because I find when my husband, I'll give you an example. My husband looked for one of his books because he's also an academic, and he found the book but with the wrong author. So he knew that it was wrong because he wrote the book, but AI was giving him the wrong answer. Anyway, an older person like myself or my husband would know, and I know like somebody on our board said, I know when AI is wrong because I've got the right experience. But the younger workers won't know that. And again, you have to go for the analog, let's read the book, and then let's train somebody so that they actually know when AI is wrong.
Thank you for that. Let me take one or two questions or comments from the audience. Yes, please.
So thank you. I have a unique experience. I actually work in AI. I apply AI to laws and to legislation, and using both the Eurovac and the Eurolex, as well as U.S. legislation. So I have an interesting comparison. First thing I will say on this topic is that you should not ever rely on AI to make a decision. And this is not an anti-AI. This is what does AI do? What does an algorithm do? It amplifies a particular pattern, right? Because they see that pattern, they classify that pattern as the correct or wrong. It doesn't think. Please really remember that. It does not think. It is a pattern recognition machine. That is it. And it's very sophisticated. It can do it in supervised, unsupervised, carry histories, understand multiple languages. So it is extraordinarily sophisticated, but it should never be used to make a final decision. Okay, so that is my professorial statement, having worked with it in a lot of different contexts. But what it is good at is, let's go back to the pattern recognition. And here I'm using hierarchical embedded topical models where you can find patterns within the legislation to understand when you have, say, rulemaking requirements, appeals procedures, and when those are most effective. And if you want to understand resiliency in a society or a country and think, you have to look to its legislation and its laws. And so this is a way to do a comparable way in which you can understand the extent to which countries can handle external shocks, where they can handle differences of conflict within internal discussions and cohesion and issues that you've been raising. So I think in those cases, it's a very good way to come up with very detailed patterns that help us understand under what conditions various combinations of rules, laws, regulations work to enhance stability, cohesion, the ability to absorb immigrants, all of those types of what we see as shocks to our democratic systems. So for those reasons, I think it's a very good tool. As opposed to cases where you're trying to bring people together in large discourse. Again, it amplifies loud voices, right? The thing. So I would be very cautious about it being a tool for civil society or building civil action, because it only will enforce those particular little segregation and micro. It won't create connectivity amongst the different aspects of it. So I guess those are some of the cautious things that I would say, but I also think it's one of the most important things.
Thank you.
Sorry.
Thank you so much
Sorry
for
to
that.
have gone to lecture mode.
Thank you. Any other comments, remarks? The ambassador, maybe you want to comment from relevant experience in the rule of law spectrum?
Yes, thank you very much. I want to echo what I heard with a lot of interest in the Trinity Long Room discussion the other day, and Patrick was there. You had a very prominent journalist in the panel. I can't recall his name, Patrick, if you can help us with his name, in the panelist. And he was saying that what is the biggest dangers for him, for democracy and rule of law, is what you're calling logarithmic justice. He was saying about logarithmic journalism. He was saying that because the young generation now, they just go down and scroll their social media, the logarithms decide what news they're going to run. I mean, Patrick was there and he was chairing there. If you can elaborate, I thought it was fascinating. I've never heard that argument, but so much impressed me. Thanks.
Yeah, Mark Little, the former primetime presenter in RTE, and then he set up Story.
Sorry, I'm not Irish, so I wouldn't recognize him. Yes.
But a wonderful, he was so articulate.
Yes.
I think we have that available on our website as a podcast as well, if people want to listen to it.
Yeah, excellent. Any final comments, remarks from our panelists or from anyone else? Okay, it's 1 o'clock sharp. Thanks so much for staying until this time. Very glad for the first Cyprus Forum Dublin that took place. Thank you again to the ambassador, and I wish you a nice afternoon and a good presidency.
Yeah. Yes.